In just a moment, I'll be turning the floor over to this evening's moderator, Jeff Schessel. Mr. Schessel is an historian and former presidential speechwriter. He published his first book of political history, Mutual Contempt, Lyndon Johnson, Robert Kennedy, and the Feud That Defined a Decade, in 1997. After reading Mutual Contempt, President Clinton invited Mr. Schessel to join his speechwriting team. He agreed and went on to become Deputy Chief of Presidential Speechwriting, taking the lead on 2 State of the Union addresses, as well as other important speeches. His most recent book, Supreme Power, Franklin Roosevelt versus the Supreme Court, delves into the history of the court, in particular President Roosevelt's proposal to expand the Supreme Court in an effort to push through his progressive agenda. The book was called History Come Alive by the Dallas Morning News, and an excellent work of narrative history by the New York Times. And now it's my great pleasure to introduce Justice Stephen Breyer. Justice Breyer, after graduating from Stanford University, Magdalen College at Oxford, and Harvard Law School, began his legal career as a law clerk for Supreme Court Justice Arthur Goldberg. And over the following decades, he held several positions as counsel and prosecutor within the United States government. He has also served as a professor here at Harvard Law School and the Kennedy School of Government, as well as at the College of Law in Sydney, Australia, and the University of Rome. He began his judicial career in 1980 and has served on the United States Court of Appeals, the United States Sentencing Commission. He was named to the Supreme Court by President Clinton in 1994, replacing the retiring Harry Blackmun. Over the years, he has written numerous opinions, judicial arguments, and works of judicial philosophy, including most recently the book Active Liberty: Interpreting Our Democratic Constitution. His new book, Making Our Democracy Work, explores the role of the judicial system in general and the Supreme Court in particular in the smooth functioning of our democratic society. I'd like to thank you very much for your patience this evening. I'll hand the floor over now to Jeff Schessel, but please join me in welcoming Jeff Schessel and Justice Stephen Breyer.
Thank you, Rachel. I just first want to say that it's a great honor for me to be here with you, Justice Breyer, especially in front of this, I guess we could probably call this a hometown crowd.
Yep.
I appreciate the opportunity to ask a few questions before all of you get the opportunity to do, or some of you anyway, get the opportunity to do the same thing. I should probably begin with a disclaimer. I am not a constitutional scholar. I don't even have a JD. I should probably whisper that when I say that. So with your permission, Justice Breyer, I hope we can confine this conversation to politics, sports, the weather, things like that.
No law, that's the...
I want to begin by noting a fact that may be known to some of you, and that is that the bookshelf of books written by sitting Supreme Court justices is not a particularly full bookshelf. And those books that do sit on that bookshelf tend to be memoirs, they tend to be histories of the kind that Chief Justice Rehnquist used to write, and so forth. It's very rare indeed that sitting Supreme Court justices write books about what they do all day, which is interpreting the Constitution and congressional statutes. And I wonder if you can describe to us what it is that moved you to write not only this book, but this is in fact your second in just 4 years on the subject.
Now you clearly, Jeff, I'm sorry, have missed Joseph Story, a professor at the Harvard Law School and a predecessor in my chair, who wrote 5 or 6 excellent volumes of a treatise on constitutional law.
We'll see if I'd gone to law school.
Well, no, we didn't read it in law school. Now, Jim Varenberg was the dean at the law school when I was there. I see Betty here. And through some error on his part, he never assigned Joseph Story in the class. But I'll get to your question. I want to say first that it's really very nice to be here and back. It is a hometown group. The first time I spoke to a hometown group after I was appointed, I spoke at Cambridge Ringe in Latin. That was about 4 weeks after. And a student got up, a very nice group, they said, how many amendments are there in the Constitution? Now, this is the trouble with being a law professor. So I think, are there 26 or the 27? Well, there are 27, but there was some argument about this last one, about whether it really is an amendment or isn't an amendment. So I thought, being safe, I said 26 or possibly 27. And immediately someone wrote into the Globe and said, President Clinton has nominated a moron to the Supreme Court. He said that was there. But the reason that I've written this, and actually Chief Justice Rehnquist wrote, I thought, a rather good book about the Supreme Court and how it works. And I think my motive was similar to him. I want people to know about the court. I mean, Harry Blackmun told me that. He was my predecessor in office, and he said two things. He said to me personally, he said, you will find this an unusual assignment. Correct. And he said, you will discover that people have a virtually unquenchable thirst to know what you do. They know you affect them. They know the court has some effect on what happens to people in America, and they want to know how you do it. They want to know what you do. So talk to them when you have a chance. And I have. But this is perhaps a more efficient way, or maybe less, but it gives me an opportunity to see the court and to explain the court from my point of view. I can't jump out of my own skin, and I can't describe the perfect court. And I can't even say whether I actually have the key to it, which I doubt, but I can tell people how I go about my job. And I can tell people stories from past courts. And I've tried to select stories from the past. For example, when Eisenhower sent troops into Arkansas to enforce desegregation. Some of us remember that. Or we don't remember the Cherokee Indians, where Andrew Jackson said John Marshall, who said it's their land, made his decision, let him enforce it. And Jackson sent troops to evict the Indians, the opposite of what the Supreme Court said. And we've all heard of Dred Scott. We all know that's what Paul Bator used to say. There's a picture of Roger Taney, the Chief Justice who decided the Dred Scott opinion, generally known as the worst in United States Supreme Court history. And I wanted to find out why and explain why. But there's a portrait of Taney, and not a very good one, in the Supreme Court, and Paul Bator used to come in and point to that, and he'd say, there is a picture of Roger Taney painted by Dred Scott. So there is a certain amount of storytelling in this. Korematsu. Terrible situation where the court upheld the removal of 70,000 American citizens of Japanese origin in World War II. So I want people to know, why is the court there? Why might we support this institution? Why might it be good for us, even though it will often be wrong? I hope not too often. What is this about? So through the stories and through a description of how I myself go about deciding cases in different areas, I'm trying to communicate something.
So you've been out and about a bit more than usual. You've been out talking about the book. You've been on Larry King, someplace you don't frequent, I wouldn't think. And I wonder whether you've been in closer contact with some of the misconceptions out there about the court, about its work. And I wonder if you're running into those and whether you think those are of concern, or whether it's more that there's a general lack of knowledge or lack of understanding.
I'm somewhat torn as to my temptation to answer that. I think, but I'm not sure, and a historian or somebody, a pundit or a sociologist have a greater and better view of this. But I heard, Nicholas Kristof, at the Times, describing writing his column. And he said, the problem for us is that we can get a much bigger audience if you put a Democrat and a Republican in a room and they scream at each other than you can if you tell people, he said 500,000 women or something raped in the Congo. People turn it off. But they won't turn off people screaming at each other, even if they know they should. So do I sense a little bit of that? Yes, I do. And that does motivate me in part. You know, the first thing I run into a lot, and I've seen it, is people want to say, well, what's the Supreme Court? Politics. That's what it is. Politics. And these are a group of junior varsity politicians. And I want to say that isn't how it looks to me when I do my job every day. Now, the difficulty is you can't just say no. You can say, well, that's not really the word. And I want to first tell you what it is I do and how I do it. And now, if you want to use the word politics for some of it, I wouldn't, but I'm not going to say you've totally misunderstood 100% for some of it, but you'll have a much more sophisticated understanding. And where does it go? And is it really a person's basic values? And is it really something about how he or she looks at American society that's going on? Is it a difference in upbringing? Is it a difference? It's all those things that have shaped us, you as well as me, by the time we reach a certain age in terms of our values, in terms of what we think is important, in terms of what we think the city of Cambridge like, is Massachusetts, this region, the country. All those things are part of it in some cases. So you see, this is hard to do. And I was really pleased to have that chance on Larry King, really pleased, because I'm talking to people who don't necessarily have the time to go to a law school class, and why should they? Or even to stop very often in lives that are terribly busy, jobs, children, my goodness, tough. And to think about some of this. So if I can get their attention, or some people's attention who wouldn't ordinarily think about it, and just put a question mark in their mind, I think that's very helpful. It's very helpful for our institution, and I want to explain to people why I think our institution ultimately is helpful to them.
Well, let's move to one of the central themes or arguments in the book, and that is the idea that you develop that the Supreme Court and that judges generally must, in your words, must recognize and respect the roles of other governmental institutions. I wonder if you can talk about what that means, recognize and respect. What does that mean in practical terms?
That's a good question, and I will start to tell you the answer, but I want to back up so you see how I'm getting to my answer. I wanted to start this by saying, well, why in heaven's name should absolutely traditional question, why should 9 men and women who are not elected have the power to set aside a statute passed by Congress, which is elected? Why? And I promise you the ink that has been spilled over that question would fill this entire auditorium to overflowing. So what I've got to do is avoid answering it and simply force the reader to think about it. Now, my own take on this, which I throw in, is that Alexander Hamilton, when he was thinking about this question, and the founding fathers who were there writing, well, they looked at this document they'd written, and I carry it around because it's part of my job. And they said, you know, it's possible people will look at it, read it, and they won't enforce it. It will be a picture. Let's hang it in the museum. Let's go to the FOG. Let's go to the MFA. Put it on the shelf, and people can come in and stare at it. There's got to be some enforcement mechanism, or it will be nothing other than a fine work of art. Now, how do we do that? The president could enforce it. Don't kid yourself. He will become a tyrant, says Hamilton. He's too powerful already. Well, what about Congress? Wait a minute. In this document, there are lots of protections for people who are very unpopular. And it's not so hard to enforce when it's popular to do it, but it's sure hard when it's unpopular. And you think that Congress, who are experts in popularity, believe me, they are expert. And if they weren't, they wouldn't hold the jobs they do. All right, do you think they, just having passed a statute because it's popular, are going to turn around and say it's unconstitutional? Not on your life, but we have 9 obscure bureaucratic types up here called judges, and nobody's ever heard of them, fabulous, and they have not the power of the person, not the power of the sword. They're weak, terrific, and they'll probably do their job. Let's give them the power. Now, I have parodied what he said, but it's grain of truth to that. But wait. If, in fact, these 9 obscure bureaucratic types who have no power are going to do this and uphold it when it's unpopular to uphold this document, why will anybody do what they say? You see, that's Hotspurs' question, and that's what I use to frame yours. And I say Hotspurs' question in Henry IV. It's great. I love the line. Owen Glendower comes in, and he's a Welshman. So all the Welshmen in Shakespeare are mystics. So he's a mystic, and he says, I can summon spirits from the vasty deep. And Hotspur says, well, so can I, so can any man, but when will they come when you do call for them? Now, that is the question that Hamilton did not ask because he did not know. And that is the question that Andrew Jackson with the Cherokees answered in the negative and said, we have the troops, you, Judge, do not. And that is the question when it was concerned with slavery that helped the country into a civil war, which by great luck the North won. And that then is the question that President Eisenhower had to answer at Little Rock. Because at Little Rock, some of us will remember, a few of us in this room, a lower court federal judge said, integration, end of segregation. We want black students at white Central High School, do it. The Board of Education was willing to do it, and Governor Falba stood in the door and said no. And I have the troops, he said, and you do not. And it was organized that he would meet Eisenhower up in Newport. He went there. He said, President Eisenhower dressed me down like a general dressing down a sergeant. And he told Eisenhower he would let the black students in. He came out and told the media he wouldn't. Eisenhower got a little annoyed. But Jimmy Burns, who had been on the Supreme Court and who had been in charge of mobilization in World War II and was governor of South Carolina, and a liberal, went to Eisenhower and said, Mr. President, if you send troops in, you are going to have to occupy the South. You will have to have a second Reconstruction. Are you prepared for that? The best that will happen is that they'll close all the schools and no one will be educated. But I think, he said, it will be a second Reconstruction. And Herbert Brownell goes to Eisenhower and says, you have to do it. You cannot have this. You cannot have this governor saying no, and Eisenhower did it. He called in the 101st Airborne. The 101st Airborne, some of us also remember. They were the heroes of World War II. And I promise you, Eisenhower knew it. We can remember. I remember seeing those pictures in Life magazine. They had been parachuted into Normandy, and they were hung up, a lot of them, on the steeples because the planes didn't get to the right place, and the Germans came in and shot them down. And they were heroes of the Battle of the Bulge, and Eisenhower knew just what he was doing when he put 1,000 of them on airplanes, and they flew to Little Rock, and they took those children by the hand, and they walked into that school, and that picture went around the world. I say that was a great day for law in the United States. It was a great day for the United States of America. Now, I'd like to say, oh, good, it had a happy ending, but it didn't. The next day or soon thereafter, they closed the schools, and a lot of ups and downs after that, a lot of ups and downs. And eventually up. There was all the civil rights movement. There were dozens of things. But for me, I look at that moment and say, that was a victory for law. That was an important moment. Maybe that was the moment we turned the corner on that issue. And see, I tell that story just like that. Why? Because I want you to see the good as well as the bad. I told Dred Scott in the book first. That's the bad. And I want to say, oh, it has a happy ending, but I want to leave you thinking, maybe. And we accept it like we accept the air around us because we better obey the courts or it's violence in the streets, and that's clearly worse. You're absolutely right. It is clearly worse. But you see the tough nature of this job, if you're going to convince people of this or give them a chance to learn about it, is that you have to, if you're an American and want to accept the court, accept the court as an institution that is done first and foremost there to protect unpopular people and unpopular causes. Otherwise, you wouldn't need them. Go to Congress. And by the way, they're 9 fallible people, and they will sometimes get it wrong. All right, that's the heart. Now I haven't got to your question. Because I think, okay, the person says, what would you do about it, Steve Breyer? I mean, you're up there. How do you decide these difficult things? How are you going to avoid Dred Scott? How are you going to do all these wonderful things? And there I understand what I can say. I can say, I tell you what doesn't work. One, it doesn't work to decide things politically. Dred Scott tried to decide things politically. Roger Taney probably thought he was going to avoid the Civil War. Ha, ha, ha. I mean, the dissent in that, written by a native of Massachusetts, Benjamin Curtis, was picked up by Abraham Lincoln in his Cooper's Union address. And that helped promote him and the Republican Party, anti-slavery, into the White House, and the South couldn't take it, and there was the Civil War. So if Roger Taney was being a politician, among other reasons for not having 9 political judges, is judges are terrible politicians. And that's only one piece of evidence. So I said, well, forget that. Oh, I see what judges do. You do what you think is good. I said, that won't work. First of all, I hardly ever think I get to do what I think is good. But leave that aside. It's just you'd have 9 people doing 9 different things, and you'd appoint 9 others, and they do 9 other different things. It would be a nightmare. Law couldn't work that way. Oh, I see how to stop you from doing those things you just think are good. We'll have something called originalism. We will go back and look at what the founders really liked. Well, we can get into that later. I'll promise you I don't think it works. And say, okay, you're so clever. What does? And now I have a great soundbite. And my soundbite, as I say, I'm being very honest with you, the soundbite is to say, well, we take values that are permanent, which are in the Constitution. They don't change. But we try to apply them to circumstances that do. Now, that's serious, by the way. I really believe that. But we're open to the claim, if you believe that, that's simply a 4th of July speech. Now, we're at your question. You see? And what I'm trying to say is, no, it isn't just a 4th of July speech. And I want to take those who will be put up with me for 122 pages through a series of different areas of the law and try to put legs on that soundbite. Or if you like, try to give it real substance. And the key to it, as you said in your review, for which I appreciate enormously, is you look back at what they were really trying to do with the Constitution, which was to produce a document and a government that would work, and recognize that judges are not the whole part of the government. They're a tiny part of it. There's Congress, there's the president, there are the states, there's federal, state, and 3 branches. There are a lot of different parts, or administrative agencies. And what those people who wrote that document thought was this is a framework for government for 500 years, at least. Well, let's take that seriously. And then let's try to see what different kinds of approaches we can take as judges that will help this work better when we're dealing with the President of the United States or with Congress or with the administrative agencies or with the states. And I try to spell that out.
Well, there's, on that last point, there's a...
Now you've got the whole book, by the way.
Thank you very much.
Yeah.
There's a word that recurs quite frequently in the book. It's a 4-letter word. And I was surprised by it, and it's the word help. And I was very interested in your statement that the court must help the other branches in certain instances to help them do their work more effectively, and not just other branches, but other governmental institutions. And I wonder whether you think that in a certain way cuts against the notion of the independence of the judiciary, or against the idea that judges or justices really are there to decide the case at hand and let the chips fall where they may. It might help, it might hurt. Ultimately, it can't be your concern.
No, I think the metaphor that works for me is the metaphor of the boundary patrol. I mean, there's a document, and this document is basically sets up democratic institutions. People make up their own minds about what kind of country they want. But certain kinds of democratic institutions, nobody has too much power. That's 3 branches, state, federal. Human rights are protected, basic human rights. It assures a degree of equality. It insists on a rule of law. Those are boundaries. Within those boundaries, people vote. The boundaries are very broad. We're there, and what I think of is when I used to listen to the radio when I was 8 years old, and they had Sky King. Sky King was king of the Mounties or something. He was up there in the north of Canada, patrolling the boundaries. I used to think life is tough up there, and I think we're the boundary patrol. And life is sometimes tough at the boundary. Is abortion within or without? Is school prayer inside or outside? And please, to me, there are good arguments on both sides of those questions. It's not obvious, rarely is obvious at the boundary. But what people often forget is within this very broad area, it's not up to us. It's up to the democratic process. So when I use the word help, I'm thinking not help them on any one thing, this or that, we like this, we don't like that, but rather help this process work better. I used to think there were 2 kinds of lawyers. There's the kind we don't all, and none of us know, that when the client comes in wanting to do something that seems not terrible, the lawyer says no. And he thinks of all the reasons why not. So the hospital can't do what they want because the lawyers say no. I don't know anyone like that. But I used to know the other kind that said, yes, we'll think of a way. If the end is reasonable, we'll try to see how the law can help you achieve it. Now, these are degrees. They are degrees of things. They are not absolute. But I think judges, too, should lean towards helping where the democratic process is at issue. That's, for example, well, I have examples of that, but you go ahead and ask.
Well, we can come back to the examples if you'd like to talk about those. One of the things that interested me most in this book and that I found especially provocative is the question of what happens when the court doesn't respect the roles of other governmental institutions, when the court doesn't act with that kind of restraint. And throughout you raise the question or possibly the specter of what happens if the court fails to show that respect. You warn that, in your words, that public acceptance is not automatic, which your stories help to establish, and that it cannot be taken for granted. I wonder if you can talk a little bit about that risk.
Well, you're the one who is really expert. In your book, you've actually gone through this in a very important case, which was the court packing. So you have a sense of what's going too far in the direction of major public issues, which I don't have. I can tell you in microcosm. I want to tell people a little bit about a lawyer's problem, and because it comprises really a vast amount of our cases. Really what we do, and by the way, we're unanimous about 30 to 40% of the time. The 5-4s are about 20 to 25%, not always the same 5, not always the same 4. So what I really do most of my day is I'm interpreting statutes, something lawyers love to do. There's some words in a text. So what do they mean? Now, to explain that in a simple way to people, I found a funny example. When I was in France, I read in a newspaper that there was a school teacher, a biology teacher, who was going to Paris, and he had some, in a basket, 20 live snails that he was going to show to his biology class. So the conductor came up and said, "What have you got there?" And he said, "Some snails." He said, "You have to pay full fare for the snails." He said, "Don't be ridiculous." He said, "Well, read it here. It says right here, no animals allowed on the train unless they're in a basket, and then they have to pay full fare." What? Okay? I mean, why? I mean, well, did they mean snails? Now, that's the job for us. Do they mean snails or don't they mean snails? And what are the pros and cons? And I can tell you, this would be an example of really interfering with something sensible. Suppose the court were to hold that he has to pay 20 fares, one for each snail. You see? So, getting these minor things wrong and departing from what Congress was trying to do in a statute, which is all too easy to do if you're too literal. You have to follow the text. but the text doesn't give you the whole story. You can really end up in a mess. And when I say you, I mean you, the voters, don't know who to blame. When things are all mixed up, you say, oh, it must be my member of Congress. Well, he's getting everything, passing the wrong laws. And the member of Congress say, no, it's the courts. And the courts will say they didn't write the statute right. And then somebody else will say some other thing. But if you interpret statutes in general in a way that tries to carry out what the members of Congress actually had in mind they were intending, I think it works better. And that's an example of what I mean by working better.
I guess my question following that is just how vulnerable you think the court is as an institution to jeopardizing that public trust. I think putting aside the 1930s, which I'm always happy to talk about, and looking at more recent history, you expressed concern in your dissent in Bush v. Gore that the court might be jeopardizing, in fact, its public esteem. You express, in my reading of your book, some sense of relief that, in fact, that hasn't been the case over the past decade, and that judicial review still is something that the American people accept. One might, you don't, so I won't put these words in your mouth, one might say the same thing about the Citizens United decision, that according to the Washington Post, that 80% of the public opposed, 80% of the public, I think, agreed with your view in that case, and yet, again, there has not been a wave of public antipathy toward the court in the wake of that decision. So my question then is, and this is one of those hypothetical questions that I'm sure you're not inclined to answer, but how far does the court really have to go? How far does it have to transgress before it really jeopardizes its standing in the public eye?
Well, I can't answer it because I don't know the answer. And I said, well, isn't that an unfortunate thing? So you expect me to know the answer to something like that? I think, my God, we're back at Ringe, Tech, and Latin or whatever, in Latin, and they're asking me, are there 26 or 27 amendments? And here I am being difficult. I can't express a view. If I had a view, I wouldn't express it. And I actually don't know. And the main point of this that I'm trying to get across, it's not a lecture to my colleagues. It is an effort to show other people really what this is that we're trying to do. And of course, I am thinking that I'm right. If I didn't think I was right in some of these difficult cases, why wouldn't I join the other side? But as they think they're right. You know, I mean, and that's what's so interesting for me. And there we are. I mean, I grew up in San Francisco. I've lived in this community for more than 40 years, and I thought I'd met a lot of people around here who had a lot of different views, and they get into arguments all the time. And I thought, well, I hadn't been exposed to anything. All right? I had not. And then when I'm in Washington, I see this is a very big country. And there are 300 million people in it who think a lot of different things. And people of every race, religion, point of view are in front of this court with this document, and they've decided somehow, through some miracle, to resolve most of their problems under law. Now, that may be a little corny, but I see it in my job every day, and I think it is a good thing. So, of course, I didn't think Bush v. Gore was correctly decided. I did write a fairly strong dissent where I said that. But I'm also keeping in mind what Harry Reid said about 2 years later, when I heard him talk in the Senate, and he said the most remarkable thing about this case, where he disagreed with the outcome too, but he said the most remarkable thing is something very rarely remarked, and that is despite the fact that most Americans thought it was wrong from beginning to end and very important to them, they followed it. They did not take to the streets. There was not violence. Now, I'll run into a minority who think that should have happened. And I'll say to them, do you really? Go turn on the television and look at what happens in countries where that happens. And there we are. And why I say there we are, because there is your basic dilemma. The basic dilemma is to repeat it. How is it that these 300 million will understand their processes and that document well enough so that they'll accept this institution even when it's going to do things that are unpopular and even when sometimes it will be wrong? And how do you show them those alternatives? How do you show them what we do? And there we are. That's the most I can do.
Well, this raises another question that I think is at least implicit in your book, and that is about the relationship between the court and public opinion. Jeff Rosen, in his recent and glowing review of your book in the New Republic, called attention to this question and said that he thought it was one of the unaddressed questions, at least explicitly in the book, and that is the court, to what extent is the court constrained by public opinion? To what extent should the court be constrained by public opinion? Another one of those questions on which much ink has been spilled over.
Yeah, but not by me. Because that's when, that's what, I'm there every day writing cases. And the question is, what I read in the newspaper is public opinion. How should it affect me in writing that case? The correct answer and the true answer is zero. Zero. That's not the nature of the institution. And no one thinks it does. Who's there? Or maybe they're kidding themselves. People can kid themselves. I said that once in another context, and people thought that meant I thought I was wrong. I don't. But look, good example. Korematsu, one of the darker pages of the U.S. reports. 70,000 Japanese descendants, American citizens, in January of 1942, are removed from California against their will and sent to camps in the mountain region. Now, that reaches the court. In 1944, Fred Korematsu brings the case. I met him once, actually, here on Dunstable Road, because our next-door neighbor was the daughter of someone I knew in San Francisco, Ernie Bezig, who used to work for the ACLU. And she had him over, and I had a drink with him. He was a feisty guy, and he was great. He said that his parents didn't want him to bring this case. They had a lot of pressure against him. And he said he was going to because he didn't think that could happen in America. Well, by the time his case got to the Supreme Court in 1944, and I didn't know this till I started reading about it, lawyers in the Department of Justice, two of them, one named Burling and I can't remember the other's name offhand, but they had gone into the reason. Remember, you won't all remember, but in January 42, I can't remember that time, but I was in San Francisco. I remember the blackout shades. People thought the Japanese were going to invade California. And DeWitt, who was the general in the Presidio in San Francisco, said we have to send the Japanese east because there are instances, he said, 751 instances of signaling from the shore to submarines. And then he said, there are 5 instances of sabotage. And he listed all these things in a report, and that was in front of the court. And these two lawyers were curious about that report. And so they called in the Federal Communications Commission, and they said, what are these 751 instances of signaling? Can you come back and let me know? And he asked the FBI. They asked the FBI, what about this sabotage? And they came back, the FCC, 2 weeks later, had a report like this. And it said there wasn't one, not one. We looked up all 751. There were young draftees, buck privates, who didn't know how to work the equipment. And we found every single one. There wasn't one. Well, what about, and they said, well, how did you do that so quickly in 2 weeks? He said, what do you mean 2 weeks? We did this at the time. And we showed this, the FCC, to General DeWitt in 1942. Before the Japanese were sent away. And what about the sabotage? The FBI came in with the same thing, and they pointed out that the person who had told DeWitt not to do this name means something to some of us, the person very strongly opposed, don't do it, his name was J. Edgar Hoover. And he said, there's no need, we know who the spies are, and it isn't them. All right? So they tried to put this in front of the court, and it was a very complicated story. It's very interesting. They got it in front of the court in a footnote. And Charlie Horsky, who was the ACLU lawyer, pointed that out to the court and said, read that footnote. And nobody believes this, and nobody did believe it. And the court still decided for the government and against Korematsu. Question, why? See, you want to say, well, it's public opinion. No, I don't think it was. I mean, these people who wrote that, on the majority, it was Black and Douglas and Frankfurter. They were they were civil libertarians. And the person who was right, in my opinion, was Murphy. Nobody ever heard of it. He went into this factually, and he said, it never was so, it's not so, there's no justification, don't do it. So why did they do it? Well, my own belief, because they couldn't figure out how not to. They're thinking, either Franklin Roosevelt runs the war, or we do. And once we get into the business of second-guessing the military, there's no stop to it. And I think that's why they didn't do it. So that, to me, poses a real challenge, where you have the security of the United States at stake on one side, and the court's told that. And on the other side, you have traditional civil liberties. How does the court do it? And to put that in institutional terms, the war power is given to the president, supported by Congress, and the civil liberties power is given to the court. There is difficulty. Now, you say, is there an answer to that? I don't know. But what I want to point people to are the 4 Guantanamo cases. Because I think those 4 cases, in each one of which the court decided in favor of the Guantanamo inmate and against the President of the United States or the military, I think those 4 cases represent an effort by the court to struggle with this question. How do you protect civil liberties and hold the president accountable without, to use Justice Jackson's words initially and Arthur Goldberg later, without turning the Constitution into a suicide pact, which it most certainly is not? Now, those are difficult cases, and put in those very general terms are the kinds of things that I think judges today and in Korematsu, though I think their answer was wrong in Korematsu, but those are the kinds of things that judges are struggling with. And if you tell them the opinion poll in the New York Times or in Pew Research or in the USA Today says they're 72% unpopular, say, okay, fine, what do you think we're appointed for? You know? And so that isn't really the question in front of us. The question in front of us is how. How do we reconcile, for example, these very strong goods on both sides, threatened bads on both sides, where we have different institutions of the government responsible for different things, where the court's power is fairly constrained, where et cetera, et cetera. And that's how I really mean to answer your question.
Mm-hmm. I'm going to ask what for me will probably be a closing question, because I know there are a lot of questions out here. You are often described in news pieces about you as an optimist. I don't know if you would cop to that publicly. Okay. Let me put it another way and see if you'll cop.
No, I like being an optimist. Why not be an optimist? I mean,
you have expressed, and I think that this book in many ways is an expression of your faith in the democratic process, your faith in democratic processes. And this is something from your very first statement, I think during your confirmation hearings. You have made clear as your love of democracy. Okay, maybe I'm reading that wrong. I'm not.
No, that's fine.
Okay. Well, and I wonder if this is clearly a time of very little optimism in this country, whether it's about the economy, whether it's about the Congress itself, whether it's about the ability of the nation to solve some of its most significant challenges. And on the left, among those who tend to agree with you and your decisions and your dissents, there is little optimism about the direction of the court as well. And I wonder whether you can speak what you say to those who are losing heart. I'm not asking you to be the nation's cheerleader here, but if you have more cause for optimism than they do, I wonder what you might say to them.
I'd say, first, in your characterization, which is fine, but if there's any group of any political view that agrees with all of my decisions, either I haven't been writing them correctly or they haven't been reading them. I mean, there is no way that, I mean, some are one, some are the other, and that's true, I think, of all 9 of us and anyone who's on the bench. And in respect to the optimism, the book I recommend, because it made a big impression on me, is Henry Adams, The Education of Henry Adams. Why? because he starts off in a really different world, in a world where they thought in America they were going to replicate a form of aristocratic England. They thought that would be the social mechanism. They didn't know what was coming. And he's born into the only aristocratic family in the United States. His father was not king. His grandfather was president. His great-grandfather was president. And there he is. And he's been trained for public service. And what he sees begins to appall him. He goes to the South and sees slavery in action. And he says, oh my God, this isn't civilized anything. This is terrible. And he's in the Civil War, and then the post-Civil War, and we don't know them, but we read in school those NAS cartoons. Do you remember the NAS cartoons where they had the Senate, and behind all the senators, there were all these big money bags, and one says the oil trust, and the other says the steel trust, and another says the copper trust, and what they meant was they were really buying senators. I mean, right, left, and center. And go back and look at a little of that history. And Adams is getting more and more discouraged in his autobiography. And he wrote a great novel about this called Democracy, which I really recommend. But he ultimately ends up, well, what's the choice? What's the choice? You say, and that I'm in that sense. It's the Winston Churchill story, which everybody knows, that America always, always, always does the right thing after exhausting every other possible alternative. All right? And and we think, what do we have as a base here? I usually like to think, though it's a little corny, I think it's the 5th grade. And in the 5th grade, it's very common when I was in the 5th grade, and still is. You take 5 students, and you give them a project, and you say, the 5 of you get the project done. And what's interesting about that mechanism for teaching is it isn't going to end up with one of those 5 students bossing somebody around. They've got to cooperate to get the project done. And they've got to suppress their own ego a little bit and listen to a few others. And that's common enough in our educational system. And I think it's common enough that when things look bad, we start figuring out how are we going to get it to work. Now, that's how I was brought up, okay? That's San Francisco, that's Massachusetts when I've lived in it, and I've been very depressed on a whole lot of things, and then suddenly, okay, it's a little corny, but I see Churchill had a point here, and even with what Sandra O'Connor is doing and David Souter, is they spend a lot of time saying what we hope you're going to do, and I'm right with them, is that let's go back, not to the 5th grade, but at least to the 12th, and make certain that high school students learn something about civics. You know, why? It's because they've got to know how this Constitution works. They've got to know how the local thing, or I'm sorry, I'm on a soapbox. But if you say that there is a hidden motive here, that's the hidden motive. There it is. I mean, please. 300 million and their children have to work this country. And we have pretty strong mechanisms for doing it. But they don't work unless the people know the mechanisms and they know a little of the history about it and they're willing to get out and do it and participate. Okay, that is the commercial. So we're going to get a commercial break. Yes.
I did invite you to step up on that soapbox.
Yes, right.
Good evening, Justice Breyer. Can you talk a bit about the court's evolution in dealing with cases involving gay people, and also where do you expect the court to go on that issue from here on?
The one case that probably was the most prominent was Lawrence versus Texas. And in that case, there was a statute forbidding homosexual conduct in the home among consenting people, very rarely enforced, and the court held that that was contrary to the Constitution because there was no rational basis for it. Now, that's where we are, basically. And as far as what will happen, we both know, and probably all the people here know, that there are various cases pending in the lower courts. And the one thing I can't do is comment on those, even by a raised eyebrow or anything. Because, and there's a good reason, there's a general rule against making a comment or a suggestion about a case that might come to us. And in general, the reason's this. I promise you one thing. What I might say at a cocktail party is quite often different from how I feel about an issue once I've had a chance to read through 50 briefs, very well researched. Think about it. Hear an oral argument, talk to my colleagues about it. And it's hard enough, and I shouldn't be, and none of us should be, hampered by the fact that we might have expressed our opinion publicly when it was less known before. And that's why I can't really give you an answer of the kind you'd like.
I understand, but one follow-up. Could you talk just very briefly about the court's evolution getting to the Lawrence decision? Because obviously it was very different from its Bowers v. Hardwick decision just a few years before.
Well, the court, you have to read it. So if I'm going to talk about a court case, that's another unfortunate thing. We write opinions that are fairly long. And in that opinion, I summarized it about as much as I'm prepared to do. But you can, if you really want to follow it in detail, and this has helped us a lot. We have a SCOTUS blog. You go Supreme Court and actually 1 million people look at it. And on that blog, it's great because you just call up the opinion and you get the whole thing. Now, I grant you that sometimes I torture people when I'm in dissent by writing a long opinion, and I figure that's going to fix the other side because they'll have to read it. But by and large, they're fairly understandable. And it tracks the line I just gave you in a sentence.
Okay, thank you.
Okay?
Good evening, Justice Breyer. We now have 3 women on the Supreme Court and no one openly gay. Do you believe having 6 women and 3 men would lead to different decisions? And would it make any difference to have anyone openly gay?
Well, Justice White, Byron White, said one time to me that with every new appointment, it is a different court. And I've experienced that. And you become individuals, and I rather like it. I'm pleased that there are more women there. I think that's fair to say. And has it led to different decisions, or will it? No one can pin that down. No one knows. I mean, you can speculate, and I can too. But we don't really know because we're dealing with the individuals there in the individual case.
Thank you.
But I am in favor of having more diversity. That's no.
Thank you for joining us, Justice Breyer. So going back to your earlier mention of originalism, I was kind of curious. Justice Scalia, in particular, has been articulating a critique, textualism and originalism, that purports to be both more legitimate and also more dispositive of cases and therefore limiting of subjectivity than the kinds of functionalist and pragmatic and balancing considerations that you and the other sort of justices who are perceived as more liberal often employ. I was wondering how you'd respond to the critique that someone like him might offer.
Yeah, well, first, I think that you've actually articulated very well the rationale behind this idea of looking back to history. That is exactly the strongest rationale, in my opinion. It's a way of keeping control over the subjective influences of the judge, where he will subjectively, or she will subjectively, sort of do what she thinks is good rather than what the law requires. All right, so why do I find that not acceptable? Reasons are basically 3. First, I've had too many cases where it's just too difficult to know what the historians think. I mean, Jackson said that years ago. He says, you go back and look into history, it's more difficult to fathom than the dreams that Joseph was supposed to interpret for Pharaoh's wife. He said, now, because the difference isn't that we wouldn't look back. I would look back to see what the basic values are. But when you start getting into detail, I mean, there was flogging in the Navy. The last whipping post was taken down, I think, not until 1907. Now, does the fact that people then thought flogging was a perfectly suitable punishment mean that it's not cruel and unusual today? I wouldn't think so. But if you want to go back and see what they actually felt about something in detail, we had a case. It involved a technical matter. It isn't that technical, but it might be for a non-legal audience, an ex post facto clause. All right, now, forget the fact you're not quite certain what that is. But I'll tell you that the interpretation on that, the interpretation required us to look at what a 19th century judge meant in the precedent when he was talking about what Blackstone, who wrote in the 18th century, meant when he was writing about Sir Walter Raleigh's trial. Now, I had to figure that out because there were people with different views on my opinion, which was the majority, and I sent my law clerk up to the library to look all that stuff up. And I've said many times since then, what's the truth about what a 19th century judge, about what I know, what he meant when he's writing about an 18th century treatise writer talking about a 17th century trial? You know the truth? I don't know. And if you want to find out these things, you better appoint 9 historians and not 9 judges. And I'll tell you, when you do, you will discover that they disagree. Now, that's the least of the problems. If you want the most of the problems, think of this one. That probably, when the 14th Amendment was enacted, those who enacted those words, "No state shall deprive any person of equal protection of the laws," knew perfectly well that the schools in the District of Columbia were segregated. So does that mean that Brown versus Ed Board of Education was wrong? I'd say of course not. Of course not. Why not? Because those who passed the 14th Amendment had something in mind. They passed that because they wanted to take people who had been slaves or were descendants of slaves and say, you are welcome, you are part, you are included in American society. And by 1954, if they looked around and saw what was going on, in the name of segregation, nothing could have been more unwelcoming. Nothing could have been more uninclusive. Nothing could have been more really awful, okay? Not to put too fine a point about it. And that had happened. Of course, that amendment, which had an objective, now would say, in my opinion, and 9 justices, and everybody's considered it since, of course it forbids segregation in schools on the basis of race, because it's of objective, and because we've seen how things turned out when we tried the other. Okay? So you try that. Now, I have 19 other criticisms, but I'll spare you.
Thank you.
Yes, sir. Thank you for being here. My name is Jared Milrad. I'm a law student at Northeastern. My question is, there's been a lot of ink spilled about politicization of law clerks and supposedly the marriage between an ideology between a judge and clerks. Number one, do you think that's true? Number two,
no.
If it is true, if it's not true, do you think that that might affect the prism through which young people
No.
see the court?
Oh, I don't know how young people see it because I'm not that young. It's really unfortunate. but I'd say that, I mean, I saw the article, and I have no objection to writing the article. Fine, they wrote the article. That's sort of an interesting point. But somebody went back 6 years, I guess, I don't know if the writer did in the Times or not, and he tried to work out, everybody has 4 law clerks each year, so there were 24 law clerks, and say how many previously had worked for a Republican judge and how many previously had worked for a Democratic judge. Okay, I turned out on that. I was 13, had previously worked for a Democratic judge, and 11 had worked for a Republican judge. So I guess perfect would have been 12 and 12. So I wasn't perfect. I was 13 and 11. Okay, I had never thought before, quite honestly, whether they were working for a Democratic judge or somebody who was appointed by a Democrat. So this was a new idea to me. And by the way, Justice Kagan, she was 3 and 1. The perfect would be 2 and 2. So both of us were off by 1. Now, some people were off more than others. You'll have to talk to those people. There we are. So I love my law clerks. They're great, and I like it best when we're discussing things and we don't always agree. I don't need people around who always agree. I already have enough tendency to think everything I do is right. And it's much better to have somebody saying the opposite and giving me all the arguments the other way and going through this in depth. So we have a kind of discussion group there, and I suspect an awful lot of other judges like the same kind of thing.
Thank you.
I'm very glad you started from the Cherokees, because my question, the Cherokees versus Georgia, my question is based on that, and I want to read one short sentence from your book,
Yes.
which may be overlooked. And the sentence in the chapter on Cherokees is, then, in 1929, gold was found in Cherokee lands, and the Georgians decided to break the stalemate. They entered the Cherokee territory, began to work the gold mines. And my question is, partly in line with some of your colleagues in Harvard Law School, and they're still active in that, who maintain that the legal system to great extent serves the interest of the powers that be along the lines of Thrasymachus, beginning of the Republic, who says in every case the laws are made by the ruling party to their own interest. I'm intentionally being devil's advocate, but is there possibility that some of it is true, that without the money, presidents don't get elected, senators don't get elected, and we may be having not just democracy, but also plutocracy. I know you dissented in the corporate giving, but it goes much beyond that.
Well, that's a good question. And first, it was 1829 they found the gold. And I cannot tell you that my heart is filled with joy that you read this book with this care. And you'd have to remember in that case, the law was that land belonged to the Cherokees.
Exactly.
And the judges said it belonged to the Cherokees, and the judges were right, and they did their best there. And you can have 9 judges or 900. They don't have the armed forces, and it was the president, the political agencies, that decided that they would evict the Cherokees. So there we are. You know what Joseph Story, my great predecessor, what he said, he wrote a letter to John Marshall at that time after they said this land belongs to the Cherokees, and he said, the court has done its duty, now let the country do theirs. And as for the rest of your questions, you will have to address it to my colleagues and former colleagues at the Harvard Law School.
Do you agree with them?
That's not really. I mean, it's too complicated. In my life, I could find evidence for and I could find evidence against.
Thank you.
That's a good question.
Thank you, Justice Breyer and Mr. Shessel. Justice Breyer, in 1965, a native of my home state of Ohio wrote in the case of Griswold v. Connecticut that the law banning the use of contraception, even by married couples, is uncommonly silly, but not unconstitutional. Justice Scalia, I believe, recently said that lots of stupid stuff is perfectly constitutional. How do you or would you strike the balance between silly and constitutional?
That's good. Well, there is a lot of silly stuff that is constitutional. I absolutely agree. And I don't think I'll start giving you my list, but I have quite a few. But basically, we're not interested in whether it's silly. I mean, the cases that come up are asking us in terms of a specific text of the Constitution. Sometimes texts that are fairly well defined. Did you know, and if you did, I didn't, that there's something in the Constitution called the Tonnage Clause? No, I didn't know that either. So we had a case, and he said, this violates what Alaska's doing, violating the Tonnage Clause. Oh, my God, it did. And well, lo and behold, it did. Or at least that's what we found. We had to look into that. So we'll get cases, and it might be as specific as that Tonnage Clause was. It was pretty specific. Or it might be as open-ended, though with lots of precedent, as what is the freedom of speech in a borderline case. Cases that really come up. A cable owner is told by Congress he has to bring over his cable system an over-the-air broadcaster, and he says, I hate that broadcaster, I don't want to do it, you're interfering with my freedom of speech. Well, does it or doesn't it? Now, there's an actual case we really have, and they're not so easy. You see, but that's what we're doing. Whether it's broad or general, the Tonnage Clause, or at the borders of the First Amendment, or in the 14th Amendment, and think of your own thought. Your own thought was, they're doing all these things we read in the paper every day. And my thought to you is, that's true, but that's a very small share of the work that we do.
Thank you for coming. I was just wondering, how do you think Iqbal v. Ashcroft will affect the pleading process?
No, this is I don't always dissent. I think I did in that case. This is a case which has basically, it's a case beloved by proceduralists because it used to be, in fact, tends to be under our rules of procedure. Fairly easy to file a complaint. That my great law professor, Ernie Brown, used to tell me in the tax class, can you sue? He'd say. And then the student, the gullible student, I knew to hide at that point, that the gullible student would say no. He'd say, what do you mean? Anybody can sue. All you do is file a piece of paper and pay the filing fee. You see? All right, so it used to be almost that easy. But you're saying Iqbal made it a little bit more difficult. Yep.
Okay. Thank you.
I'm Beck Annie, American University Washington College of Law.
Question: in the past 200 years of government, the court, the political institutions used to address rather big, broad questions. And as time has gone on, the economy is increasing complexity, the political environment is increasing complexity, and the court, as well as the politicians, are faced with answering very, very detailed technical questions, whether it's in the range of economics, healthcare, anything like that. How do you feel, how adept do you think the institutions, political and judicial, are at answering these questions in this new kind of complex environment in the world that we live in? And maybe what suggestions you might have to help these institutions address those issues going forward?
It's good. That's interesting. You raise about three different things. One is, I would advise against thinking that we're just sitting there hearing cases we want to hear. Oh, this would be so interesting. That isn't how it works. Right. It's much more mechanical than people think. I mean, we receive about 7,500 or 8,000 requests for hearings every year, and we grant only about 70 or 80. But that isn't because we only want a few. There's actually a criterion. And the criterion is basically this. Chief Justice Taft, after he'd been president, explained this. He said the job of the Supreme Court is not to correct errors in the lower court's judgments. Everybody's already had a trial. Everybody has already had an appeal. Usually 2, sometimes 3 appeals. Now, I wouldn't say never, maybe it's a death case or something, but very rarely will we hear a case to correct an error. Well, what are you doing? He said, this is what we're doing. We're here to create or maintain a uniform rule of federal law. That's only about 5% of the law. That's Congress and the Constitution. 95% is probably state law. But make that uniform in a case that requires uniformity. When does it require uniformity? Almost always when 2 or 3 or 4 different judges across the country have come to different conclusions on the same question. You see, Jackson said this. He said, we're not final because we're infallible. We're infallible because we're final. Now, no one knows what that means. But what it basically means is we do not have the last word because we're so brilliant. We are, of course, brilliant. But only in the sense that somebody has to have the last word. Now, do you see what we're doing? We're looking, by and large, to see if, and that's why we could have a case involving what's the meaning of a comma in the Internal Revenue Code, which does it mean the next word, which is a for, should be read as a which or a that. We had a case like that. You see different judges that come to different conclusions. I sort of liked the case. No one else did. But the point is, or it could be the First Amendment. It could be some, and we will sometimes take a case without what you call a split because, say, the Guantanamo cases, we see that need. So we're operating more mechanically than you think. And so now we can show you the answer, or towards an answer, in the second question. If the reason that they're more technical now in our court, it's because those are the cases that are coming to us. And so you have to go back and say, well, in the period when I was a law clerk, I worked for Arthur Goldberg, it was clearly a court with a mission. And the mission was desegregation. And they had held in Brown that it violated the Constitution of the United States to have segregated law that segregated the society, and they had to make that real. And there was a lot of work to that, because that legal structure of segregation was absolutely very complex and permeated Southern society. And a lot of the cases were like that, and they involved all kinds of things that you're thinking of as major questions, which I agree with you. But then times changed. And Congress got these laws interpreted, and the Constitution got sort of worked out. Problems are still there. They're not perfectly solved, but it's a different world. And then if Congress is not enacting as many statutes, we won't have many cases. And if they start enacting technical statutes, we'll have to deal with technical cases. And that's hard. You know who pointed that out first? I found at least a reference to it. Somebody showed me in 1584. Montaigne. He writes on experience. He says there was a Roman emperor who thought that he could control all his judges. And the way he'd do it, he'd put everything in a code. And it would be so technical and so many words and so complicated, they'd have to do it. They just couldn't use their own subjective views. He said, Montaigne says, what, that man must have been an idiot. Doesn't he know that in a statute, every word is just an opportunity for lawyers to cause trouble and take 4 sides? He says they'll have more power than ever. Okay, so you're saying those are the kinds of cases we're getting. Yeah, there is some truth to that. And now, a solution, partial, it's called the administrative process. But unfortunately, it takes me 13 weeks, 3 hours a week to begin to get into it.
Thank you.
My name's Andrew. I'm a first-year law student. I just wanted your thoughts on the legal economy, I guess would be the word. I guess, as you know, the legal field's been hit recently with the layoffs and everything else, and a lot of law students have been having trouble finding jobs, and a lot of attorneys have been laid off, and so right now there's a lot of lawyers out of work, and I just wanted to know how that's affected legal academia, the law itself, the stuff like that, and assuming there's going to be an influx of lawyers, hopefully if the economy picks up, how that would affect legal academia, the law, and maybe democracy even.
In our court, it doesn't affect us directly.
Yeah.
In the lives of people like you, it might.
Yeah.
And the only thing I tell sometimes to the law students is stay calm. And it's hard coming from me because I have a steady job, and it's not meant to be funny for the others who don't. And it's a general part of a societal problem. And I have confidence that eventually, and my father's generation saw this. They saw it in a worse form.
Yeah.
They saw it in a lot worse form. That's probably why he told me that his final advice: stay on the payroll. but I understand the problem and I sympathize with it, and I think it is the same problem that millions of Americans going through. And if older people say it'll change and things will get better, and you say, how do you know? And I have no good answer. So I wish you the best.
Thank you. Thank you, sir.